So Charlotte, let's say we do have a plan that we don't like at the school or local authority level. So can you tell us a bit about what parents might be able to do there?
Yes, so let's have a look at reconsideration and appeal, which is part 6 of our seminar. So, firstly, under section 26 of the Act, if a governing body of a maintained school has made a decision about a pupil's additional learning needs, whatever that decision is, or if they just refuse to make a decision about it, and the child or the child's parents, or if we're talking about a young person, the young person asks the local authority to reconsider that decision, or a governing body of a maintained school maintains an IDP for the registered pupil, and the child's parents or a young person asks the local authority to reconsider the plan with a view to it being revised. So firstly, if a governing body effectively decides that the pupil doesn't have ALN or refuses to make a decision one way or the other, or secondly, the governing body is maintaining an IDP and the child or the child's parents or the young person is dissatisfied with the content of the plan, in either of those events, they can ask the local authority to reconsider the plan or reconsider the decision. And the local authority then has 7 weeks in which to reconsider that decision, unless the following exceptions apply. So firstly, the local authority does not have to do a reconsideration if it has previously reconsidered the IDP and it is satisfied that the pupil's needs have not really changed since that decision and there's no new information that would really affect it. Or secondly, the request relates to a child who has become looked after by a local authority, except if that child is in the area of a local authority in England. Or thirdly, the pupil has become subject to a detention order. Now, reconsideration, as we note on this slide, is the only right. I mean, we say appeal, it's really the only way to reconsider directly or to challenge directly a school governing body's decision, because the appeal rights in relation to the tribunal only relate to the decisions of local authorities and further education colleges. But there is, so that's the first step, if you like, under section 26. You can ask if you are dissatisfied with the decision that's made in respect of your child's needs or your needs if you're a young person, or if you're dissatisfied with the IDP that is currently being maintained for your child or for yourself, then you can ask the local authority to reconsider that decision. Going on to point 6.2, what happens when the local authority decides, what happens when the local authority is considering taking over the plan? Well, under section 28 of the Act, if the governing body or the FE college is maintaining an IDP for a child or a young person, and if the child or young person asks the local authority to consider taking over responsibility for maintaining the plan, then the LA must make that decision unless either the local authority has previously made a decision under the same section in relation to the same child or young person and is satisfied that nothing has materially changed since last time and there is no new information that would affect the decision, or the child has become looked after. Those are the exceptions to the duty. If the local authority decides to take over responsibility for maintaining the plan, then it will be treated as, the plan will be treated as being maintained by the local authority. So you don't have to kind of make a new IDP, it effectively transfers to the local authority's control. And secondly, from the date of the local authority's notification of the decision, the governing body will no longer be required to maintain that plan. Going on to 6.3, we've talked briefly about rights to the Education Tribunal of Appeals, the Educational Tribunal for Wales. So what can you appeal? Well, firstly, you can appeal a decision by the governing body of an institution in the further education sector, so an FE college, under section 11, or a local authority's decision under sections 13, 18 or 26 as to whether a person has additional learning needs. So it's important to bear in mind that you do have a right of appeal in respect of a local authority's refusal to reconsider those decisions that we were talking about in the earlier slide. Secondly, you can appeal, if you are a young person, a decision by a local authority under section 14, 1C as to whether it is necessary to prepare and maintain an IDP. You can appeal the description of a person's ALN in an IDP. You can appeal the additional learning provision, the ALP in an IDP, or the fact that ALP is not in a plan, including where the plan specifies that additional learning provision should be provided in Welsh. You can appeal against the provision included in an IDP under Section 14 or Section 19, or the fact that provision under those sections is not in the plan. You can appeal the school named in an IDP for the purpose of Section 48 of the plan. You can appeal the fact that there is no school named in an IDP. You can appeal a decision under Section 27, as we were just looking at, not to revise an IDP. You can appeal a decision under Section 28 not to take over responsibility for an IDP from a governing body. You can appeal a decision to cease to maintain an IDP. You can appeal a decision under Section 32 that a governing body should cease to maintain a plan. And you can appeal a refusal to decide a matter on the basis that the exceptions that we've looked at in Sections 11, Section 13, Section 18, and Section 29 apply. In other words, you can appeal the finding of a local authority that they are not going to review or consider a particular issue because they think that there's been no material change in needs and no new information that materially affects the decision. And the appeal must be issued along with a case statement. So you have to say why you're appealing within 8 weeks of the decision appealed. Going on to part 6.4, what can the tribunal do once you have appealed? So once the tribunal has determined your appeal, what can it do? Well, firstly, regrettably, it can dismiss the appeal if it considers that the appeal wasn't properly made out, there wasn't enough evidence to support it. Secondly, the tribunal can order that a person does have or doesn't have ALN of a kind specified in the order. So in other words, the tribunal can make a decision about ALN and it can record that in an order. Thirdly, the tribunal can order a school, an FE college's governing body or a local authority to prepare an IDP. It can also make that order in relation to revisions to an IDP. So it can order an FE college or a local authority to revise an IDP as it specifies in its order. It can order the governing body of a maintained school in Wales or an institution in the further education sector in Wales or the local authority to continue to maintain an IDP with or without revisions. So that's in respect of a cease to maintain. It can order a local authority to take over responsibility for maintaining an individual development plan. It can order the governing body of an FE college or a local authority to review an IDP, and it can remit the case to the governing body of an FE college or a local authority for it to reconsider whether, having regard to observations made by the tribunal, it is necessary for a different decision to be made or a different action to be taken. And that's obviously quite an interesting addition to the powers that the Welsh Tribunal has, as opposed to, for example, the English Tribunal. So those are the rights of reconsideration and the rights of appeal. That was quite a technical canter through, and I do apologise for that, but it's quite difficult not to look at that technically because it's all about mechanisms for appeal and where they arise. So I'm really interested, Mike, as a long-standing expert in this field, what do you think of the way that the Act is restructuring rights of appeal?
Well, it's interesting. I mean, pretty much it's giving another step in the process, isn't it? Whereby all the key decisions ultimately that are likely to end up with a challenge are going to have to be made by the local authority because they have to make the decision whether to inherit the plan and so on. So I think that in terms of one of the big concerns that I have is in practice, where is it going to leave a child who, let us say, has special educational needs requiring a package of speech therapy, 1 hour, 2 hour a week or whatever, and who then says they're not getting it? Is it going to result in practice, those parents not having a right of appeal to the court in judicial review because there's this mechanism whereby the local authority could be challenged about it taking over responsibility, either taking over or not taking over responsibility of the plan? So that interests me, or at least I'm not sure whether or not you agree with me on that, Charlotte, but that's one of the key points for me that sticks out, namely that there's this another sort of vehicle or process that a parent would have to go down before going to the sort of immediate result that much more immediate anyway than by applying for injunctive relief and emergency in the High Court. What do you think of that?
I think that's right. I suppose that in theory, if the dispute between you and the school teaching your child was, you were saying that the school could reasonably be expected to provide something without recourse to the local authority, and the school's saying, no, we can't, I suppose potentially you could then judicially review the school on the basis of, well, the act doesn't really provide for that, in a straightforward, where the school's saying, we don't need anything else from the local authority, but we're not going to provide what you're asking for. And you're saying, but it's reasonable to expect you to provide that. We agree you don't need to go to the local authority, but it's reasonable to expect you as a school to provide that. That's the sort of situation where I think you could JR under this, because there's no remedy for that situation. But I agree with you, Mike, the pressure really in that situation would be for the parent to turn to the local authority, wouldn't it?
Yeah, and you see, and the trouble with that is that you're right, there's no remedy. But you know, Charlotte, as well as I, in practice, a court looking at this will say, well, why didn't you ask the local authority to inherit this? If the key point, which is that this speech therapy, for example, in my scenario, is not being delivered. Therefore, clearly, you can demonstrate the very good reason why, because this school can't deliver it, why the local authority should inherit it, because they are the one who is empowered and have the financial resources to deliver it, and therefore go down there. Don't trouble the administrative court. That's what I'm thinking in practice. That's the kind of responses I think we're going to get. And then young people, there's two things that emerge from that. One is my point, which I've been labouring on all day today, that you're, again, maintaining this feud between the parents and the school. That's the one thing. But more importantly than that, the child is going to be delayed in getting that support. And that's what I foresee as an area of concern that I've always had from day one, when this was even at bill stage. Chris, those are my points. Do you agree with that?
Well, it's going to be really interesting, isn't it? I think there are a number of good points in this act that I think do help when we talk about rights of appeal. Firstly, when we talk about, as we did earlier, about the fact that there is a duty to decide whether a child or young person has ALN, I think it's very good that not only do they only have limited statutory grounds on which to refuse that, and those statutory grounds are essentially that we've made this decision recently and nothing has changed, but you also going to get the right to appeal that decision to the tribunal as well. So it limits institutional and local authorities' abilities to kind of step out of responsibility for deciding whether a child or young person has ALN, but still gives the right to appeal there. And gives a lot of various, rights of appeal. And I think, Mike, talking about, as you say, the point you've talked about much today is that tension between schools and parents, and that tension between institutions and parents. I mean, I think there is some sympathy I have with colleges here, because, of course, they don't have the shield of the local authority, to take them through. They will be defending themselves at tribunal. And that's something, obviously, that they've never had to do before. It hasn't been possible for a college to go before a tribunal here in Wales before, because it was dealt with under a different act, as we discussed at the start. But certainly in England, where you can have FE colleges named as placements, they can come as witnesses, but they're not your opponent. The local authority is always your opponent. And I think it really will be tough for them to manage appeals, I think, because it's a totally different ballgame for them. And then if they feel, well, we need, legal advice and support to do this, which you can understand, given that unlike the local authority that will have education officers and staff who will probably be trained to represent the local authority at that level, and of course will have its own legal team if it really needs, a solicitor or possibly even a barrister to represent them. For colleges, who's going to fund that legal advice as well? It's going to be a real minefield out there, I think, for FE colleges. And, although, of course, as a children's rights lawyer, my side is always with the children and young people. I have some sympathy. For them, I must say.
Well, Chris, it's funny because I've never really seen schools and colleges being in a different camp to children. My main reason is that I've always seen them as partners. And this is the whole point that I was making from the very moment, when this bill was created, that this is my concern. The idea that there's going to be a crash course needed for the further education sector, exposure that the further education sector, we haven't really gone into that in great detail in this presentation, but exposure to challenges by young people. And I have enormous sympathy for schools. I always have, and I still do. That I think this legislation is placing a great expectation on them.